Observations on the Defense of Purchase for Valuable Consideration Without Notice by Freeman Oliver Haynes, published 1880, 89 pages. Chapter 1. It is proposed to give in the following pages a sketch or outline of the equity doctrine in respect to the defense of purchase for valuable consideration without notice, distinguishing what may be considered as settled from what must be regarded as still uncertain. This investigation cannot be considered as of mere speculative interest, for the Judicature Act 1873 provides that the High Court and every judge thereof shall give to every equitable defense the same effect as the Court of Chancery ought to have given to it in any suit or proceeding instituted by that in that court before the passing of the act. And that generally where there is any variance between the rules of equity and the rules of the common law with reference to the same matter, the rules of equity shall prevail. B. We will endeavor first to ascertain as nearly as we can what were the rules and doctrines of the Court of Chancery with respect to the defense of purchase for value without notice, and then consider their application or possible application to litigation arising or to arise since the Court of Chancery became merged in the Supreme Court. It may be premised that by purchaser for valuable consideration without notice is meant a person who has paid or given money or money's worth for property or some interest in property without knowledge or the reasonable means of knowledge of some claim against the property or the interest therein purchased already subsisting at the time when the consideration was paid, and the occasion for the defense arose upon the person entitled to the prior undisclosed claim, taking some proceeding in the Court of Chancery, impeaching or tending to impeach the title of the purchaser. The question is, under what circumstances and to what extent was the defense a bar to such proceedings, and what is the rule or principle which governs or determines the validity or otherwise of the defense? Now a reference to the judicial authorities discloses an amount of conflict in the decisions greater perhaps than has attended the development of any other equity rule or doctrine, and such statements as we find of any general principle are almost equally at variance. In many cases decided by judges of the highest authority, we find expressions which taken literally amount to this, that the defense is under all circumstances an absolute unconditional bar. Thus Lord Northington says, A purchaser without notice for a valuable consideration is a bar to the jurisdiction of the court. Lord Loughborough, though he certainly did not always adhere to the principle, B is found saying on one occasion, C. I think it has been decided that against a purchaser for valuable consideration without notice, the court will not take the least step imaginable. Lord Eldon, in a celebrated judgment, expresses himself thus: I am not aware that follows as a principle of sound equity if the principle of the court is that against the purchaser for valuable consideration without notice to the court, without notice, the court gives no assistance. D. Lord Leonard says, in my opinion, whether the purchaser has the legal estate or only an equitable interest, he may, by way of defense, avail himself of the character of a purchaser without notice, and is entitled to have the bill dismissed against him, though the next hour he may be turned out of possession by the legal title. And Lord Romilly says, my opinion is that when once you establish that a person is a purchaser for value without notice, this court will give no assistance against him, but the right must be enforced at law. Now, the first observation to be made upon this apparently overwhelming a concurrence of high legal authority is that the acceptance of the principle, as laid down in its simple, unqualified form, would be repugnant to the everyday practice of the Court of Chancery and of its virtual successor, the Chancery Division of the High Court of Justice. For instance, it is clear That the defense has no application where a person claiming a cestocade trust invokes the jurisdiction of the court to obtain distribution or administration of a trust fund, which is either in the custody of the court itself or in that of a third person who is before the court in the character of trustee. If, in such a case, the fact that a claimant later in point of time of purchase was a purchaser for value without notice could be regarded as a reason for the court not exercising its ordinary jurisdiction, the result would be to paralyze the action of the court altogether, since clearly the claimant earlier in time of purchase must have taken without notice of rights which were not even existent when his own were acquired. Some limitation or qualification of the principle as was stated is absolutely necessary. What is it? The reported decisions afford, so far as the writer is aware, no direct answer to this question. In a case which came before Lord Westbury, and in which the universal unqualified nature of the offence was strongly insisted on at the bar, his lordship, while denying the universal application of the defence, made no attempt to define completely the limits to its application, but contented himself with classifying the cases in which the defense had been held to be properly applicable, and with distinguishing the case before him, those so classified. The judgment of Lord Westbury has been the subject of much comment, and cannot, it is considered, be regarded as unimpeachable in all respects. But the classification of cases adopted by him is sufficiently accurate for general purposes, and as it is the only one possessing any sanction of judicial authority, it is proposed to adopt it here for the purpose of discussing and considering the cases themselves. After this discussion, but not until then, some attempt may perhaps be usefully made to discover the principle or circumstances limiting the application of the defense. Lord Westbury says, in effect, in the case referred to, there appear to be 3 cases in which the use of this defense is most familiar. 1. Where an application is made to the auxiliary jurisdiction of the court by the possessor of a legal title, in which case the defense, Lord Westbury says, is good, and the reason given is that, as against a purchaser for value without notice, the court gives no assistance, that is, no assistance to the legal title. But Lord Westbury continues, this rule does not apply where the court exercises a legal jurisdiction concurrently with courts of law. And he cites, in support of this exception, Williams v. Lamb and Collins v. Archer. 2. Where there are several purchasers or encumbrancers, each claiming an equity, and one who is later in time succeeds in obtaining an outstanding legal estate or some other legal advantage. And the principle is that a court of equity will not disarm a purchaser, which is the common doctrine of the tabula in naufragio. Tabula in naufragio, literally a plank in a shipwreck, a graphic expression applied to the saving of a junior equity by acquiring the legal title. 3. Where there are circumstances that give rise to an equity as distinguished from an equitable estate, as for example an equity to set aside a deed for fraud or to correct it for mistake. Following then Lord Westbury's classification. Let us first consider the cases of application by the possessor of a legal title to the auxiliary jurisdiction of the Court of Chancery. These cases may be conveniently ranged under the heads of bills for discovery and native proceedings at law, bills for discovery and for the delivery of title deeds, or for the removal of terms in bills to perpetuate testimony. Lord Westbury, in his classification, expressly mentions a bill for the delivery of title deeds, referring to Walwyn v. Lee as an instance of application to the auxiliary jurisdiction of the court and we are here merely following his classification. But the question whether a particular head of equity jurisdiction should more properly be regarded as exclusive, concurrent, or auxiliary is often attended with difficulty. Thus, specific performance might be considered exclusive, insofar as a court of equity alone afforded the particular remedy; concurrent, insofar as it is exercised concurrently with courts of law jurisdiction in respect to the particular contract of sale; and auxiliary, insofar as the particular remedy afforded by the court of equity aided in defectiveness of the remedy given by the common law court. According to the last of these aspects, a bill for the delivery of title deeds would certainly would correctly be regarded as an application to the auxiliary jurisdiction. As respects bills for discovery, the leading case of Bassett v. Nosworthy, A, is one of the earliest and most authoritative decisions. There, an heir at law filed his bill against a person claiming his purchaser from the devicee under the will of his ancestor in order to discover a revocation of the will. The defendant pleaded that he was a purchaser for valuable consideration bona fide and without notice of any revocation, and the plea was allowed. And upon the truth of it being established by evidence, the bill was dismissed. The bill sought also to set aside encumbrances which the defendant had bought in to protect his purchase. In delivering judgment, Lord Nottingham, then Lord Keeper Finch, thus expresses himself: the purchaser bona fide, without notice of any defect in his title, at the time of the purchase made, may lawfully buy in a statute or mortgage of any other encumbrance, and if he can defend himself at law by any such encumbrance bought in, his adversary shall never be aided in a court of equity by setting aside such encumbrances, for equity will not disarm a purchaser. Oh, do I have bona fide? Ooh, that's long. Not too big. Bona fide purchaser. One who purchases let's see if I can put this. No, not that. One who purchases a chattel for value without notice of a defect in the title of the person from whom he purchased, or of the right of a seller in the chain of title to avoid or rescind the sale which he made. One who purchases real estate with an honest purpose and for a valuable consideration, without knowledge or notice of outstanding interests, or of facts or circumstances from which his knowledge of outstanding interests should be implied. Possession of realty by one other than the grantor is sufficient to require the purchaser to make inquiry as to the rights of such other person in possession. To constitute one a bona fide purchaser entitled to priority over one claiming under a prior equity or conveyance, he must be the purchaser of the legal title, as distinguished from the equitable title, in good faith, for value, without notice, at or before the time of parting with the consideration of such other's equity or conveyance. Larkins v. Howard. Equity will not disarm a purchaser. So that sounds like a maxim of equity. A more distinctly typical instance of the simple bill for discovery occurs in the case of Gerard v. Saunders, B., which came twice before Lord Loughborough. On the first occasion, although the defense of purchase for value without notice had been pleaded, Lord Loughborough held that the purchaser must answer on oath as to all facts relevant for the purpose of determining whether he actually had notice. To the oath as to the facts relevant for the purpose of determining whether he actually had notice. Upon an answer being put in submission to the decision, an attempt was made to extract further discovery going beyond the question of notice, and thereupon Lord Loughborough held the answer sufficient, saying, I am perfectly satisfied upon the general reasoning that this court will never extend its jurisdiction to compel a purchaser who has fully and in the most precise terms denied all the circumstances mentioned as circumstances from which notice may be inferred, to go on to make a further answer as to all the circumstances of the case that are to blot and rip up his title. To do so would be against the known established principles of the court. Then follow the words already quoted. I think it has been decided that against a purchaser for valuable consideration without notice, this court will not take the least step imaginable. We will now consider bills for the delivery up of title deeds. At law, antecedently to the Common Law Procedure Act 1854, which conferred powers to compel specific delivery of chattels, though by distresses only, a somewhat ineffectual process, the legal owner of title deeds could recover from the wrongful possessor of them in an action of trover, damages only, and in an action of detenue, the deeds themselves, or at the option of the person wrongfully detaining them, their assessed value. In a fitting case, the Court of Chancery supplied this defect in the common law jurisdiction by ordering the wrongful holder of the deeds to deliver them up to the rightful owner. In Walwyn v. Lee, a tenant for life under a settlement suppressing the settlement affected to mortgage the property in which he had a life estate only, and handed over the earlier deeds to the mortgagee. On his death, the remainder man under the settlement filed a bill for discovery and to have the deeds delivered up. The mortgagee pleaded that he was a purchaser for value without notice, and Lord Eldon upheld the defense. At first blush, the decision seems of doubtful policy. Tenants for life of settled estates are habitually, as of right, the holders of the title deeds of the property in settlement, and the result might seem to be to favor the wrongful deposit of such deeds. The question, however, was not one of policy, but of the principle by which a court of equity was to be governed in such cases. In pursuing its own principles, the court gave to the remainder man, who was legally entitled to the deeds, no assistance against the purchaser for value without notice, but at the same time left him free to assert his rights at law as best he might. Lord Eldon, after adverting to the imperfection of the jurisdiction at law in reference to the recovery of the deeds and pointing out that the plaintiff was seeking the special assistance of a court of equity to recover possession of them, said, is it not worth consideration whether the very principle of this plea is not this? I have honestly and bona fide paid for this in order to make myself the owner of it, and you shall have no information from me as to the perfection or imperfection of my title until you deliver me from the peril in which you state I have placed myself in the article of purchasing bona fide. Is it not worth consideration whether every plea of purchase for valuable consideration without notice does not admit that the defendant has no title? If he has a good title, why not discover? I apprehend there is sufficient ground for saying a man who has honestly dealt for valuable consideration without notice shall not be called upon by confessions wrung from his conscience to say he has missed his object in the extent in which he meant to acquire it. Next, the possession of the deeds at least is a thing purchased with the estate, and if it happens that the purchase misses its object to this extent that the purchaser has had the possession taken from him without the assistance of the court, is there a clear principle that therefore the possession of the deeds shall, with the assistance of the court, be recovered by that person who so obtained possession of the estate? I am not sure that follows as a sound principle of equity. If the principle of the court is that against a purchaser for valuable consideration, this court gives no assistance. Lord Eldon, after thus characteristically disclosing his own views on the subject behind a thin though continuous veil of interrogation and hypothesis in the first instance, reserved final judgment mainly in consequence of the recent previous decisions of Lord Loughborough in Strode v. Blackburn, A, which Lord Eldon felt to be wrong, but was unwilling to overrule without due consideration, and ultimately allowed the plea. In Walwyn v. Lee, the handing over of the deeds was an adjunct, so to speak, to a fraudulent mortgage by a tenant for life. The more recent authorities seem to suggest a doubt whether the principle of that decision applies to a case in which the whole transaction consists in a mere wrongful deposit of deeds. In the case of Joyce v. de Mulliens, be decided by Lord St. Leonards, when Lord Chancellor of Ireland, the heir at law of a former owner of impropriate tithes, the true title to which was in a device thereof under the owner's will, deposited the title deeds relating thereto with his bankers. The bill sought delivery up of the deeds, but Lord St. Leonards considered that no relief could be given in equity against the bankers, they being purchasers for value without notice, and dismissed the bill as against them with costs in the subsequent case of Newton v. Newton. Lord Romilly considered that a distinction existed between the case of a deposit by a person who has seen some possibility of interests as the owner of the equity of redemption, who has already created charges, but retained the deeds, and that of a deposit by a person who has no scintilla of interest, such as a mortgagee who is a mere trustee for others, and held that in the latter case a decree could properly be made directing the deeds to be delivered up by the person with whom they had been improperly deposited, though without notice on his part of the trust. It is not easy to reconcile this view with Walwyn v. Lee. In that case, the tenant for life who handed over the deeds had certainly, at the time when he so handed them over, an interest in the land and in the deeds, but by his death every scintilla of interest had vanished. However, Lord Romilly, having, as he considered, by means of this distinction, freed himself from the authority of Walwyn v. Lee, came to a decision in direct opposition to that of Lord St. Leonards and Joyce v. de Mulliens. There was an appeal in Newton v. Newton, A, which succeeded on the ground that upon a due consideration of the material facts, the money advanced by the mortgagee was not trust money, but that of the mortgagee himself. But Lord Hatherley, in delivering the judgment of the Court of Appeal, stated that although the judges of appeal had arrived at a different conclusion from Lord Romilly on the evidence, they wished to be understood as not entertaining any opinion adverse to that expressed by him upon the question of law, and his decision that the title deeds might properly be ordered to be delivered up was treated as possibly justifiable. Lord Hatherley said There appears to us to be a material distinction between Walwyn v. Lee and cases in which either in consequence of the fund being in court, as in Stackhouse v. Countess of Jersey, A, or in consequence of the legal estate being outstanding in a trustee and the beneficial interest being claimed by several adverse but equally innocent purchasers for value without notice, the court is called upon to declare and does declare the right to the fund or estate in question. In such cases, the court is necessarily called upon to make and does make a decree against some one or more of such purchasers for value. But such a decree would obviously be incomplete in a material particular if, while declaring the plaintiff to be absolutely entitled to the whole beneficial interest in the estate, it left the title deeds in the possession of one of the defendants, claiming to hold them under an adverse title, which the same decree declared to have no valid foundation. Upon the distinction thus suggested by Lord Hatherley, two observations occur. The first, that in such cases as Walwyn v. Lee and Joyce d. Mullins, the value to the purchaser of the defense set up by him was materially lessened by the circumstance that after all he remained liable at law in an action of trover or detenue, and yet the court of equity declined to deprive him of such small advantage as the possession of the deeds might confer. In such a case as Newton v. Newton, no action, as it would seem, would have lain at law, and by the decree to deliver up the deeds, the far more substantial advantage possessed by the purchaser would be taken away. The second is that Lord Hatherley would seem to regard such a case as Newton v. Newton as not falling properly within Lord Westbury's first class, and the doctrine established by Walwyn v. Lee as being therefore not applicable. However, in the more recent case of Heath v. Crelock, A, which was that of a purchase from a mortgagor, the mortgage being fraudulently suppressed, the Court of Appeal, while giving relief by way of foreclosure against the purchaser who had not the legal estate, held that it could not properly direct him to deliver up the deeds in his possession. This case must be regarded as completely rehabilitating if this were needed. The decision in Walwyn v. Lee, it establishes, moreover, incidentally, that the principle of that decision is not to be infringed even indirectly. On the hearing in the court below, a decree had been made under the statutory power for sale instead of foreclosure, and as incidental to the sale, for delivery of the deeds by the purchaser for value. On appeal, the Lord Chancellor pointed out that the court was not in the habit of ordering a sale unless it could go on and give possession and ensure the handing over of the title deeds, and that this was precisely what the court could not properly do against a purchaser for value without notice, and that for that very reason the decree ought to be varied by decreeing foreclosure and not a sale. And Lord Justice James, after laying down that the court had no right to interfere with the purchaser for value, went on to say that it would be interfering with him if, through the form of a decree directing a sale instead of a foreclosure or anything of that kind, it merely did indirectly that which it could not do directly, deprive him of possession of the land, A, or deeds. A. Lord Westbury and Phillips v. Phillips. De Gex, Fisher, and Jones denied that possession of the land ought to be regarded as a legal advantage, of which a purchaser for value is not to be deprived, saying it was indeed said at the bar that the defendants being in possession had a legal advantage, in respect of the possession of which they ought not to be deprived. But that is to confound the subject of adjudication with the means of determining it. The possession is the thing which is the subject of controversy, and is to be awarded by the court to one or to the other. But the subject of controversy and the means of determining the right to that subject are perfectly indifferent. But the subject of controversy and the means of determining the right to that subject are perfectly different. The argument, in fact, amounts to this: I ought not to be deprived of possession because I have possession. The purchaser will not be, oh, great. It disappeared. Wait, maybe it's at the bottom of the page. Will not be deprived of anything that gives him a legal right to the possession, but the possession itself must not be confounded with the right to it. It disappeared. Oh, pop it here. Reappeared. The principle of decision applicable to cases of bills for discovery or for discovery and delivery of title deeds applied equally to bills by a legal owner to prevent the defendant sued by him in ejectment from setting up old terms or other legal interests. This is established by the passage from Bassett v. Nosworthy, already cited, A, to which may be added, as a fair typical instance, the modern case of Goulburn v. Alcock. B, in that case, a lease for 61 years had been granted by a person who represented himself to be owner in fee, whereas he was, in fact, only tenant for life, with power of leasing, and the lease was bad as not being in conformity with the power. On the death of the tenant for life, the remainderman brought ejectment against the assignee of the leasee, who thereupon got in some old terms. The bill sought to restrain the assignee of the lease from setting up the terms, but it was held that he was entitled to do so, and the bill was dismissed with costs. The same principle applied also, it is conceived, to bills for the perpetuation of testimony. In Gerard v. Saunders, C, we find Lord Loughborough saying, in reference to a purchaser for valuable consideration without notice, I believe it is decided that you cannot even have a bill to perpetuate testimony against him. The case which Lord Loughborough had in his mind was probably the Kinnell v. Arnold, A, which was a bill by a devicee to prove a will and perpetuate the testimony of the witnesses to it. The defendant pleaded purchase without notice, and the plea was allowed. The case is not a thoroughly satisfactory authority because it does not appear that there was anything to prevent the plaintiff from bringing ejectment against the purchaser, and the arguments presented to the court on behalf of the purchaser for value were rather arguments in support of a demurrer to the bill for want of equity than in support of the plea. Still, the fact remains that the plea was allowed. We pass now from Lord Westbury's first class of cases, viz., those in which the application is to the auxiliary jurisdiction of the court, to the exception laid down by him, and in support of which he cites Williams v. Lamb, B, and Collins v. Archer, C, to the effect that the defense does not apply when the court exercises a legal jurisdiction concurrently with courts of law. These two decisions will require a detailed examination. Their history is as singular as that of any that have contributed to the creation of case-made law, and their ultimate fate as decisions must be regarded as still doubtful. They were originally in terms rested, or considered to have been rested by the judges who decided them on a supposed doctrine, that a plea of purchase for valuable consideration is of no avail against a plaintiff who comes into equity asserting a legal title, and the special notice which they have attracted has been due mainly to that circumstance. They must now be upheld, if at all, by means of the distinction suggested by Lord Westbury. The doctrine on which they were founded has been authoritatively denied to exist, yet, and yet the decisions themselves have been treated as binding as well by one of the judges who repudiated the existence of the doctrine, a, as by Lord Westbury in making the exception which is now under consideration. It will be more convenient to consider the alleged doctrine first. We find it alluded to in an early case, B, in which Lord Nottingham is represented as saying, where the plaintiff hath a title in law, there, though the defendant doth purchase without notice, yet he shall discover writings, but otherwise it is if the plaintiff hath only a title in equity, for there, if the defendant purchased without notice, he shall never discover nor make good the plaintiff's title. However, in a case occurring less than 4 years earlier and contained in the very same volume, C, Lord Nottingham is reported as not only deciding that an heir relying on a legal title has no right to discovery, but as saying that the court will not compel the showing of writings to any person unless he hath an equitable title as a mortgagee. It is to be noted, moreover, that any such decision as that in Rogers v. Steele would have been distinctly opposed to Lord Nottingham's considered and fully reported judgment in Bassett v. Nosworthy, A. already discussed. In truth, these old cases in Freeman's reports are too shortly and too imperfectly reported to carry any weight. Neither does Rogers v. Steele, nor indeed either Williams v. Lamb or Collins v. Archer, contain any judicial statement of the ground upon which the supposed doctrine was founded. It may possibly have arisen from some ill-considered application of the reasons sometimes alleged, in cases falling within Lord Westbury's second class, for the non-interference of the court against a purchaser for value without notice, viz., that he has an equal equity and also law in his favor, b. say by getting in an outstanding legal estate, and thence it may have been inferred, however unsoundly, that when a man comes to a court of equity, having both law and an equal equity, the court ought to give him relief against the purchaser for value with having only an equal equity. In Collins v. Archer, A. Presently to be considered, an attempt was made at the bar to support the supposed doctrine by the argument that a defendant, in order to avail himself of the plea of being a purchaser without notice, must have either the legal estate or a better right than the plaintiff to call for the outstanding estate, and consequently that plea can never be made use of against a plaintiff who relies on a legal title. The answer to this argument is that except in the cases falling under or resembling those in Lord Westbury's second class and presently to be considered, it is certainly not necessary that a defendant should have the legal estate or a right to call for it in order to entitle him to set up the defense. And even if the argument could be regarded as sound, we find no trace of its having been judicially adopted. The question seems generally to have been viewed almost as one of a technical rule supported by some decisions and opposed by others, but for which no principle or reason is assigned, except perhaps by those setting up the defense, on whose part the contention has been that according to the general principles of equity, the defense ought to be considered as an absolute, unqualified bar under all circumstances. A short summary of the decisions bearing on the point down to and including Bowen v. Evans v. will be found in the 11th edition of Lord St. Leonard's Vendors and Purchasers, upon the result of which Lord St. Leonard's expresses his opinion to be that the defense holds good against a legal title, but there is no discussion or elucidation of the principle upon which the question in doubt is to be determined. In Joyce v. de Moulins, already discussed, Lord St. Leonard's held that the defense of purchase for value without notice was a shield as well against a legal as an equitable title. And in a case decided in 1853, Lord Romilly, after pointing out the weakness already adverted to, of the argument in Collins v. Archer, continued thus. The cases of Wallen v. Lee and Joyce v. de Moulins expressly determine that the defense of purchase for value without notice is a good defense, where the right sought to be enforced is a legal right, and I have in vain endeavored to discover upon what ground it can be held that it is not a defense against a claim in this court. This court certainly does not favor legal any more than equitable rights, but rather the contrary. Further on in the same case, we find Lord Romilly marshalling, so to speak, in opposite ranks, without any detailed discussion of them, the decisions supporting and those negativing the soundness of the supposed doctrine, the former of which consists solely of Rogers v. Seal, Williams v. Lamb, and Collins v. Archer, to which it is believed no addition could have been made. In a case decided by him only a year later, which we shall have to consider further on, we find Lord Romilly referring to Williams v. Lamb and Collins v. Archer in terms which appear to recognize them as valid decisions upon special grounds, but only after reiterating this view that the defense of purchase for value without notice applied as well against a legal right as an equitable right. Finally, in the case of Phillips v. Phillips, from which we have taken our classification, decided by Lord Westbury in 1862, we again find Williams v. Lamb and Collins v. Archer treated as valid decisions, but only on the special ground that in them the court was asked to exercise a branch of concurrent jurisdiction, so that in the result, Roger v. Steele, the untrustworthiness of which has already been exposed, is alone left to support the supposed doctrine, doctrine opposed to the whole of the cases contained in our first class, and which may justly be regarded as exploded. Let us now consider the two cases themselves. William v. Lamb, was that of a bill by a widow praying discovery of the lands out of which she was dowable and an assignment of dower. At the time, a widow might either sue for her dower at law or file a bill in equity for the same purpose. The jurisdiction of the Court of Chancery as to dower was technically concurrent only with that of the common law courts, but in practice its superior efficacy led to its being almost exclusively resorted to. This superior efficacy lay in the power of the equity court to compel purchasers from the widow's husband to disclose the facts requisite to determine whether the widow was or not dowable out of the lands purchased by them. To the bill of the widow in Williams v. Lamb, a plea of purchase for valuable consideration without notice, going to the relief as well as the discovery, was put in. Lord Thurlow is recorded as saying, the only question was whether a plea of purchase without notice would lie against a bill to set out dower, that he thought where the party is pursuing a legal title, as dower is, that plea does not apply, it being only a bar to an equitable, not to a legal title. He therefore overruled the plea. The first observation that occurs upon this case is that it is somewhat difficult to see how the plea of purchase for value without notice could ever properly apply to a bill for dower. Dower is not a claim of the existence of which a purchaser can, in the absence of distinct notice, have no notion or suspicion. The purchaser buys from a vendor of full age. It might well be said that he is bound to take notice that the vendor is or may be married, and that if he chose to make no inquiry on so important a point, he must abide the consequences of his omission. We pass by, however, the difficulty referred to, and proceed to the question whether, notwithstanding the broad ground on which Lord Thurlow based his judgment, the case may not be regarded as having really decided nothing more than that the court would, notwithstanding the plea of purchase for value without notice, exercise its ordinary concurrent jurisdiction of assigning dower to a widow. A learned author, A, in referring to the decision, upholds it as sound saying, when it is admitted that the dower is a mere legal right, and that a court of equity, in assuming a concurrent jurisdiction with courts of law, professedly acts upon the legal right, that court, in analogy to law, where such a plea would not be looked at, decides that, in this instance, the same equitable plea is also inadmissible. This analogy, it is obvious, does not hold when the widow applies for equitable relief, as the removal of terms. In such cases, the equitable plea of being a purchaser for value without notice cannot, as it would seem, be resisted. In the first case, the widow proceeding upon the concurrent jurisdiction of the court merely enforces a right which the defendant cannot at law resist by such a mode of defense. In the second case, she applies to the equity of the court to take away from him a defense which at law would protect him against her demand. It is not clear whether Mr. Roper, in this passage, intended to put discovery on the same footing as removal of terms. It certainly should be, and the argument for the plaintiff in Williams v. Lamb, as shortly reported, would seem to have been. It may be admitted that the plaintiff is not entitled to discovery, but at all events the plea is bad as going to relief as well as discovery. That the plea was in fact a good plea to the discovery paid must be considered as established by the decision of the Court of Common Pleas in the case of Gom v. Parrott, A. in the year 1857. There, a widow, instead of adopting the ordinary course of filing a bill in equity, brought a writ of dower at law. She then applied for inspection of the purchaser's purchase deed under the 50th section of the Common Law Procedure Act, 1854, which authorized the court to make an order for inspection of any document to the production of which either party is entitled for the purpose of discovery or otherwise. The purchaser met the application by swearing that he was a purchaser for value without notice, in contending that as a court of equity would not under such circumstances have compelled a discovery, neither could the court of law do so under its new jurisdiction. Thus, incidentally, a review of Lord Thurlow's decision in Williams v. Lamb and of the latter authorities became requisite, and the Court of Common Pleas, after such review, felt that the weight of authority was greatly in favor of the proposition that no bill for a discovery could have been maintained, that the defense therefore applied to the case under consideration, and that the demandant, it as the plaintiff in the writ, was not entitled to inspection. Are we missing page? All right, we're missing page 26 and 27. B. Lamb, as decided by Lord Thurlow, in which nothing was said at the bar or otherwise about concurrent jurisdiction, and in which the law is laid down broadly that the defense is only a bar to an equitable, not to a legal title. Is the case which is followed. It appears, however, from another part of Sir John Leach's judgment that the circumstance that he was exercising a head of concurrent jurisdiction was present to his mind, for in reference to a subordinate question, viz., as to the time from which the account should be taken, he expressed himself as follows. In these cases, a court of law and a court of equity have concurrent jurisdiction, and inasmuch as in a court of law the plaintiff could recover the arrears for 6 years before the commencement of the action, the defendant here must account for the tithes for the 6 years previous to the filing of the bill. It is from this portion of the judgment, no doubt, that Lord Westbury derived the conclusion that the true ratio decidendi of Collins v. Archer was that the application was to the concurrent jurisdiction of the court, and having reached that conclusion, he applied, by an ex post facto process, the same explanation to the decision of Williams v. Lamb, which neither in argument nor judgment contains any allusion to the circumstance of the concurrent jurisdiction being invoked. In an elaborate review by Lord St. Leonard's in the 14th edition of the Treaty on Vendors and Purchasers, of the whole question of the validity of the defense as against a legal title, his lordship, in discussing Phillips v. Phillips, and more particularly the observation of Lord Westbury that the defense does not apply, for the court exercises a legal jurisdiction concurrently with courts of law, makes the following remark. It will be observed that the decisions in Williams v. Lamb and Collins v. Archer were not made on the grounds now suggested. We have endeavored to show to what extent there may be reason for inferring that the decision in Collins v. Archer at least was made on the ground suggested. The ultimate result of the consideration of the two decisions of Williams v. Lamb and Collins v. Archer seems to be that they clearly are not sustainable on the ground of the defense of purchase for value without notice being unavailing against a legal title, and that the opposite views of Lord St. Leonard's and Lord Westbury render it doubtful whether they can be supported on the ground of the application having been to the concurrent jurisdiction of the court. Having regard to the difference of opinion between two such great authorities, and to the absence of anything showing conclusively that Sir John Leach's decision was really founded on the circumstance of the invoked jurisdiction being concurrent, it may be permissible to point out that if the true principle in such cases be as contended for by Mr. Roper, that the court of equity is to afford the plaintiff the same relief as, but no more than, could be obtained at law. For instance, as established by Gom v. Parrott, A. No discovery, the natural course for the court of equity to take would seem to have been to say, we can certainly do no more for you against the purchaser for value than could the common law courts. And so, instead of involving ourselves in repeated discussions at various stages of the litigation as to whether this thing or that thing is or not in excess of your remedies at law, we will leave you to assert your title in the common law courts. Woohoo! Oh my God. That was a trip. Bam. Did that make sense? I think it twisted my brain. Let's go. Drop down. Twink.